mitigation of damages. So essentially what it means is a plaintiff cannot milk the case. That would be wrong, right? No one wants to help out someone who's failing to help themselves. So the law actually puts that duty on a plaintiff to do what they can do to make themselves better, make their situation better. Now, this plays out in numerous ways. The most common are in regard to medicine, your medical treatment, and wage loss in employment. I'm just going to deal with medical treatment as an example in this video. So one of the most common ways that a plaintiff finds herself facing an argument that she didn't mitigate her damages is the failure to go to doctor's appointments. If you fail to go to your doctor's appointments, you're giving the insurance company a pretty easy argument that you failed to mitigate your damages. The insurance company will say if you would have gone to the appointments, if you wouldn't have skipped a month of physical therapy, you would have recovered. And 6 months later, now you're having pain, but it's not their responsibility because their duty to pay got cut off at the time that you failed to do what your doctor told you to do. Now, if you just miss one appointment, if you have an emergency, you have to pick up your kid from school because he's sick, that's fine. That's not going to be enough to sustain an argument that you failed to mitigate your damages. But missing repetitively or obviously not following doctor's orders, that's going to be a problem. Another common way is medications. A lot of people understandably don't want to take medications. No one wants to deal with side effects or with pain medications, even the possibility of addiction. But when the doctor prescribes it and tells you to take it, then it can move into this, and you don't take it, then it moves into this question of whether or not you've failed to mitigate damages. And if you have a question about any of that, talk to your doctor about what's really, really necessary. Not only will that more likely get you to the right medical answer, it actually will help you in the argument of whether or not you mitigated damages too, because you're taking steps to find out and to make yourself better. Similarly, if you don't follow the doctor's limitations in regards to lifting or doing activities like sports, insurance company will argue that you failed to mitigate your damages. The last example I'll give that we see fairly often is in regard to surgery. Understandably, no one wants to be cut open. No one likes surgery. So when a doctor recommends surgery, then it becomes potentially an issue of failing to mitigate damages if you decide against it. Now, the law goes into several elements in deciding whether or not you mitigated damages, considering how expensive it is, what the side effects are, what the risk of the surgery are, lots of factors. But that is a common issue, and if you're in that situation, you definitely need to talk to your doctor to make sure you get all those answers for medical reasons, but also for legal reasons. And if you're in that situation, of course, we encourage you to talk to an attorney. So what if you're in that situation? What if you've made all those mistakes that I talked about? Didn't take medication, missed some appointments, don't want to do the surgery that the doctor has recommended. What do? Is your claim over? No. But you do need to talk to an attorney. There are arguments that your attorney can make, and that's why we encourage everyone who's injured to speak to an attorney and at least get educated so you can make the right decision. If you have any questions about this or any other legal issue, give me a call. Jamison Allen, Marc Lopez Law, 317-632-3642. Be safe.